I, Costigan, Costigan, initial C, appear today on behalf of Mr. Selders. Mr. Selders is being charged with 9 counts of break and entering and 1 count of stealing. We respectfully submit that the court, pursuant to its power under Section 130 of the Queensland Evidence Act, should find that the evidence relied on by the prosecution is inadmissible on fairness and public policy grounds. Mr. Selders is a 14-year-old Torres Strait Islander boy from Townsville. As a result, Mr. Selders' young age and cultural background are relevant factors that ought to be considered when being questioned by police officers, as well as in these proceedings. Now, it's my understanding, Your Honour, that you are aware of the facts of the case. That being so, this then brings me to my first submission. As per Ironley, if a piece of evidence probative value is substantially outweighed by its prejudicial effect, it should be deemed inadmissible on grounds of fairness. We submit that Mr. Selders' confession obtained by the officers during questioning in the car and at the station should be deemed inadmissible on these grounds. In questioning Mr. Selders, the officers failed to adequately consider our client's young age and cultural background. His short responses and averted gaze during the questioning in the officer's car, coupled with the confession at the station without the opportunity to speak to a lawyer, family member, friend, or a support person, is indicative of gratuitous concurrence. It is our opinion that this evidence is of low probative value due to this and would have a substantial prejudicial effect on a jury. As such, this evidence should be deemed inadmissible as it would be unfair to be utilised. This then brings me to my second submission, relating to public policy grounds. The officers in question have deliberately disregarded and violated obligations under the Police Powers Responsibility Act and the Police Powers Responsibility Regulation, henceforth referred to as the PPRA and PPRR respectively. Firstly, a police officer who suspects a person to be a child cannot question them without allowing that child to first speak with a support person they have chosen and to allow for that person to be present during question. As per Section 421, subsections 1 and 2 of the PPRA. We submit, Your Honour, that it would have been fundamentally clear to the arresting officers that Mr. Selders, a 14-year-old boy, was in fact a child and thus applicable to these rules. On the available facts, a support person was not present whilst Mr. Selders was being questioned at the property, nor whilst he was being questioned in the officer's car. This would amount to a violation of Section 421 of the PPRA. Whilst we do acknowledge that a support person was present during questioning at the station, the person was A, not freely elected by Mr. Selders, B, only advised Mr. Selders to answer all questions posed by the officers, and C, only spoke to my client for a short period of time. This is simply inadequate and would still amount to a violation of Section 421. Secondly, if a police officer reasonably suspects a person to be an Aboriginal or Torres Strait Islander person, the officer must inform the person that legal aid will be contacted and subsequently, as soon as reasonably possible, contact a representative of that organisation, as per Section 420, subsections 1 and 2 of the PPRA. This policy was also violated by the officers, as legal aid was never contacted before any questioning was completed. While the prosecution, however, may attempt to raise the exception stipulated in subsection 3, given Mr. Selders' young age, it is unlikely that he possessed the adequate knowledge or level of education to not be disadvantaged. Furthermore, the officers did not, on the facts, ask any question to ascertain Mr. Selders' level of education or understanding, as per Schedule 9, Section 22, subsection 1 of the PPRA. Thus, it is in our opinion that these actions amount to a clear violation of Section 420 of the PPRA. Thirdly, the officers have failed to appropriately caution Mr. Selders that is being asked to be questioned and is not under arrest, pursuant to Schedule 9, Section 22, subsection 1 of the PPRR, and to his right to remain silent, pursuant to Schedule 9, subsection 26, subsection 1 of the PPRR. Thus, the officers have also violated section 431, subsection 1 of the PPRA. Finally, the officers did not notify or attempt to notify parents or the chief executive that Mr. Selders, a child, was arrested pursuant to obligations under section 392, subsections 1 and 2 of the PPRA. Nor did the officers inform Mr. Selders of his right to speak to a friend or lawyer or family member under section 418, subsection 1 of the PPRA. Your Honour, in considering these violations, we would like to raise the case of Bunning and Cross. I respectfully submit that you should find that this evidence should be excluded on public policy grounds, as the breaches to the PPRA and PPRR were severe, extensive and deliberate. The evidence, while pivotal to the prosecution's case, has a low probative value for the reasons discussed earlier and due to the number of severe breaches that have occurred. Furthermore, there was no indication of a pressing nature that could justify the officers' deliberate disregard of the procedure stipulated in this legislation. Finally, we submit that stealing, whilst it is a punishable offence, is not such a severe offence to the extent that it could justify these deliberate breaches. This evidence was obtained with total disregard to procedures that protect the justice system and ensure all people are treated with fairness. Your Honour, I would like to enter a non-guilty plea on Mr. Selders' behalf, and I ask for the court to exercise its discretion to exclude this evidence on fairness and public policy grounds. Thank you, Your Honour.